Good morning and good evening and greetings to everybody. This is Bill Wood speaking to you from the heart of Oxfordshire. Very good to see you all. First thing I want to do as I introduce Capsule One is to remind everybody how much we owe to our sponsors. I'd like to acknowledge their contribution and note that their generosity has made this webinar possible, and their logos can be seen on your screen. And in particular, the title sponsor for this webinar are Commercial Mediators Asia Pacific. I'd like to acknowledge their contribution as the title sponsor, as well as all the other sponsors whose generosity has made this webinar possible. There they all are. If we could go back to the slide showing the distinguished panel that I'm about to introduce, that would be great. Splendid. The questions we're going to tackle center around the question of encouraging the courts to use the right means for international dispute resolution. And we've set ourselves three questions: how the courts can play a role in encouraging parties to use mediation in international commercial disputes, how does MedArb or ArBMed work, and what is the role of arbitral institutions in promoting the use of multi-tier means of dispute resolution, and how can dispute resolution lawyers, just heard the Chief Justice talking about them at the end of his remarks, how can dispute resolution lawyers help clients to explore ways of resolving disputes with the most efficient and effective procedures? We've got just over an hour and a half, so in my chair's mental clock is running at about a half an hour a question, and we could not have a more distinguished panel to help us tackle these questions. We have Mr. Justice Lam from Hong Kong. There are biographies of all these good people in the materials before you, but we're delighted to have Mr. Justice Lam, Vice President of the Court of Appeal in Hong Kong, Chairman of the Judiciary's Working Party on Mediation, and the Family Proceedings Court Users Committee, and a member of the Steering Committee on Mediation set up by the Secretary for Justice. So we're delighted to have Justice Lam with us. We also, well known to many of you on this call, will be Sarah Grimmer. She's Secretary General of the Hong Kong International Arbitration Centre. Before that, she was Senior Legal Counsel at the Permanent Court of Arbitration in The Hague. And before that, was with the ICC after a period in private practice. So an immensely distinguished international dispute resolution pedigree there. Michel, you've already met this morning. He is a very old friend of mine. I'm delighted to have him with us. 12 years ago, he left Littleton Chambers, which he headed with great distinction after a very distinguished career at the bar, and immediately established Independent Mediators Limited, who we would have to concede, all of us in London, is the commercial mediation powerhouse in our midst. Immensely distinguished figure, and among many distinctions, did crucial work on the Singapore Convention as an UNCITRAL delegate, where he also worked with George Lim, who's George Lim SC, who's with us from Singapore. George, again, an immensely distinguished career in private practice. Now a full-time mediator, very busy, very successful, chairman of the Singapore International Mediation Institute, and as I say, a vital figure in the progress of the Singapore Convention. Last but not least, Tom Stepanovich. The headline about Tom, of course, is that he's the chair in dispute resolution as a professor of law at Pepperdine University. But as well as a hugely distinguished career as a trainer, a coach, an academic, a writer, and a speaker, he is himself a hands-on mediator and arbitrator of great distinction with a thriving practice quite separate from his academic life. So we have all the right people before us. And the questions we're going to tackle, we're going to start with the question of how the courts can play a role in encouraging parties to use mediation in international commercial disputes in particular. Lots of food for thought already from the Chief Justice this morning, but I wondered if we could keep the discussion on the bench for the moment, and I wondered if I could ask Justice Lam to start us off on that topic. and give us his thoughts on that question.
Yes, thank you, Bill, for the kind introduction, and good morning to everybody. It's good morning in Hong Kong, but it may be good evening or even good afternoon. I'm going to talk about the role of judges and courts in encouraging the parties to use mediation. I think we have to first ask the question, why should the court or the judge be involved? The Chief Justice has talked about CJR, but more particularly with regard to mediation. Actually, in our rules, I think it's the same or more or less the same as the English rules. We talk about proactive case management in the rules which we introduced by way of CJR. And Order 1A, Rule 4 includes various underlying objectives. The 3 or 4 objectives which I wish to highlight is that we need to identify issues and decide if which issues need full investigations. We should also encourage parties to use ADR and also help parties to settle. And most importantly, we have to consider cost and benefit of taking a step. I say we have to consider these questions because recently we are doing some consultation of our new initiatives, and that there are still lawyers who question why should the court be involved, and also some of the lawyers still took the views that the role is to play a role as advocate rather than to have any role to play, at least in front of the court or in the course of court proceedings, to facilitate mediation. So that's why we need to highlight the importance of what is the underlying philosophy for case management. Why should the judge be involved? Because firstly, you mentioned the underlying objective, which is the legal process. But as the Chief Justice reminds us, the purpose of litigation is not just litigating for the purpose of fighting. Rather, it is a means to resolve disputes. And the judge is in a unique position because it is a judge who have an impartial view on proportionality and whether the parties should consider and actively or give more force to mediation. Now, what has happened in Hong Kong is that we have this Practice Direction 31, which has been introduced since the beginning of the CJR in 2010. What this practice direction requires is that the parties have to fill a form called a mediation certificate as an early stage of the proceedings after the close of pleadings. By that certificate, the party has to tell the court whether they will agree to go to mediation. And if they do not, they have to explain why. Now, in our experience, most of the parties in proceedings will say, well, they are willing to go for mediation because I think lawyers would find it, yes, lawyers will find it difficult to find out, to give a reasons for not actually going to mediation. But we also provide that they should also give mediation notice and response so as to start the process going. And also we have cost sanctions against those who unreasonably refuse to go to mediation. Now, after a couple of years with the implementation of this practice direction, we find out there could be problems in several respects. Firstly, as the Chief Justice also mentioned just now, there are people who just regard this as ticking the box. So they take the box and they say they will go for mediation. Sometimes they simply did not move forward towards it. Sometimes that could be picked up by the court, and then they will say they will go for mediation. But there are other cases where they go for what we call sham mediation. They just go there, but are not going to achieve anything. And sometimes that might be because that was not the right timing. So we find that notwithstanding the requirement of the practice directions, the lawyers there are still some lawyers who are not very embracing the culture of mediation, and they are not just making good use of this platform. Of course, go back to the role of the judiciary, that of course we can impose court sanction, but court sanction is only secondary. What we are primarily interested in is to facilitate the parties to explore the use of mediation and to make an informed decisions on the mode for dispute resolutions. This is rather important because what I think is after all, mediation is a consensual process. You can't force people to settle. They have to actively embracing it. They have to participate in the process in good faith. They have to be sincere. They have to come up with realistic options. They have to take the step forward on their own part. So this is the concept of the ownership of the dispute. And what is important for the judiciary is to recognize that no matter how the judge would tell them, they have to let the parties and the lawyers to really understand the benefits to be derived from this alternative process. And of course, as the Chief Justice also mentioned just now, there could be dynamics arising from conflict of interest, because sometimes the parties might wish to drag on for a bit, and they think the longer the litigation lasts, the better for them. There could be that sort of consideration, and there could be consideration on the part of the lawyers that they may say, well, obviously for the case to last longer, they may have derive more earnings from it, that kind of considerations. But one important thing, as I mentioned earlier, is to let the party realize how to make an informed decision to find out a cost-effective and efficient mode to resolve the dispute. And to do that, the court's role is to sort of make them aware of what is actually going on. And that's why it's important to enable to have a platform that the parties themselves attend before the judge. Now, that is the underlying consideration behind what we are going to introduce next year in the district court, what we call case settlement conference, which is a more enhanced mode of the court involvement with the process of mediation. Actually, we have a pilot scheme in the district court last year, and in which what we have is we engage some external mediation masters who are lawyers as well as experienced mediators to be involved in case management process. And what we find out is that with their involvement, those cases going through that process achieve a settlement rate of 43%. After consultation and also deliberation as to how the scheme can be refined. We are going to introduce it early next year for a period of 2 years. I'm not going to go through the statistics with you today, but the overall result is quite encouraging. Now, the underlying concept for that is to have a platform for the court, the lawyers, and the parties to work together in a proper attempt to arrive at an informed decisions as to what are the efficient mode to resolve the dispute. We recognize there are cases which are suitable for mediation, there are cases which are not suitable. But the important thing is to give the ownership of the dispute back to the parties so that they make informed decisions. Because after all, settlement has to be voluntary. What we try to do is to provide the parties. Firstly, the parties will have to attend court together with the lawyers. And also, the court will ask them to place before us the information about cost, not only in terms of cost incurred, but also cost to be incurred in the future. And the court will explore for the issues that are before the court, whether we really need to go through all the issues, or maybe we can narrow down the issues. And some may be able to be resolved in the case settlement conference. Now, of course, the lawyers have to be cooperative, and also they have to explore and explain various options to the parties, and they have to abandon their adversarial mindset in this process of case settlement conference. But as the Chief Justice mentioned, we already have the requirement of duty to cooperate in our rules after the CJR. So court will make sure that that duty is performed. Another model we have attempted to be more mediation friendly in terms of the court process, which we have attempted in the family court, is to have a mediator to sit together with a judge in what we call the financial dispute resolution scheme. We are starting on that, but that has been quite an encouraging experience. So that there are other models that we are trying to explore in the coming years in order to make to give more facilitation to the parties to use mediation process. Overall, we try to achieve
可以选择调解。我们希望呢，诉讼
ADR process and the case settlement conference. We hope is to be providing a platform so that this new mode of achieving an effective way to resolve a dispute can be built into our litigation process. So that is how we are planning to go forward. And I can say on behalf of those in Hong Kong that our judges are quite aware that litigation is not an end, but only a means for resolving disputes. And we are obviously aware that there are more time and cost-effective options to resolve it. But the court requires the lawyer and the parties to cooperate, and the court's role is to ensure that lawyers and parties do really give serious consideration to these processes. Thank you.
Justice Land, thank you. For those of us who wrestle with the restless search to find the right way to encourage mediation through the rules and so on, this is all very, very encouraging, and a lot of really interesting initiatives being pursued in Hong Kong. Clearly, thank you very much for that. George Lim, I wonder if I could just go to you for a Singapore perspective on these sorts of issues. How are things in Singapore on these fronts?
Hi, Bill. Can you hear me, Bill? Yes, we can, George.
Okay, great. I was just listening to the Honorable Chief Justice's speech, and what an inspiration. Okay, I remember when the civil justice reform was introduced, and it actually came into effect on the 2nd of April 2009, right, Justice Lam? I remember that because it's my birthday. Although it commenced on the 1st of January 2010. So it's been 10 years. And at that time, I was just thinking, I took my hat off to Hong Kong because we were active in mediation in Asia at that time, in the Asian Mediation Association. I think Winston, who's chair of the Hong Kong Mediation Council, remember that. And for me, that was great because it was taking very concrete steps to get lawyers to try and get the lawyers buy-in into mediation and the parties. For us in Singapore, I can say that we have very similar rules. You have your mediation notice and the mediation response, which actually compels lawyers and parties to consider mediation at very early stage. We have the ADR offer, which is similar. You have cost sanctions in Practice Direction 31. We have cost sanctions under Order 59 Rule 5, which gives the court discretion to impose cost sanctions if the parties refuse to mediate. So that, to me, has really been a help in Singapore and in many other jurisdictions. Where the courts support mediation actively, you will find that mediation has grown. And I'm sure Bill and Michelle, that has been the position in the UK as well. So all over the world, I've been promoting mediation in Asia and teaching mediation, and like in Fiji, for example, which is so far away, but when the courts supported mediation, it came alive. So I think Hong Kong and Singapore, often people say we are competitive, we are competitors. I don't see it that way. For me, I see that we are collaborative. We can learn from each other, and I think we have learned very much from Hong Kong experience. Thank you.
Michelle, do you want to just quickly, we want to get through to our other two questions fairly shortly, but interesting material from these two jurisdictions. How are we doing? Do you want to give us a mark out of 10 for England and Wales and tell us how we're doing by comparison?
I think that, as the Chief Justice said, perfection is never achieved. We're a long way down the road. We've never actually arrived there. But I think we're doing very well at the moment in terms of the court's support of mediation. I would certainly give them 7 out of 10. What the courts have designed is a whole series of orders which judges can make at the case management conference. And I'm fascinated to see the initiative in financial disputes in Hong Kong, that you have the mediator sitting with the judge at the CMC. What a brilliant idea. Often, Bill, you and I will know of mediations which have not even got beyond go because one party produces an expert report at the last minute, refuses to disclose an expert report, refuses to give a full schedule of loss, refuses to disclose, even under mediation privilege, documents which are essential for the other side to understand their case in terms of quantum or indeed causation. And the courts can make orders for the purpose of the mediation. I think the two most powerful orders the court, was 3 actually. The first was in Halsey in 2004. I was appearing for the ADR group, and a section of my skeleton argument appears in the judgment. And the court ruled this, that all members of the legal profession who conduct litigation should now routinely consider with their clients whether their disputes are suitable for ADR. That was supported by another initiative that was in the submissions by the ADR group. Master Ungley, who was a Queen's Bench Master dealing with clinical negligence cases, devised what became known as the Ungley Order, and is now incorporated into our civil procedure rules. And if a party is refusing to mediate, he orders them to swear an affidavit, setting out their reasons why they are saying the case is not suitable for mediation. And that's before they get anywhere near trial. That affidavit is then sealed and opened by the judge at the end of the trial. And so the party that's refusing to mediate can no longer rely upon the result, as so often happens when parties are asking for their costs at the end of the case, but has to actually sit down with his client and work out good and reasonable reasons why he's not going to mediate. And the last initiative is this, is now a matter of professional practice, not to advise your client about mediation if you are a litigation lawyer. Now, I've appeared as counsel in mediation on very few occasions, but the one I should never forget, and the one that was most enjoyable, Bill, was when you were the mediator. And we sat in Cambridge. I think there was a cricket match going on just outside where the mediation was being held, and for most of the time we watched that. But that was a case which was a lesson for everybody. Clients were suing their solicitor because although the case settled 2 weeks before trial, the client said, "You didn't advise me that I could go to mediation to resolve this dispute, and I'm absolutely certain I could have got the same settlement without having to pay you £60,000 worth of costs." Now that case, or that advice, arose in 2000 in the summer, just after the Wolf reforms were introduced. And my advice to my clients who I was representing the solicitors was, if it wasn't for the fact it was within a few months of the Wolf reforms, if it was in 2001 or 2002, when I think that the mediation took place, there would be no defense. And that is the rule. There's no defense to an action if you refuse or neglect to advise your client about mediation if they sue. And is now part of the Bar Code of Conduct, the Law Society, and indeed sitting on the Professional Conduct Committee for the Bar. I have actually adjudicated on a dispute when a barrister had allegedly not given proper advice about ADR. So those three sanctions, as well as encouragements, have really pushed mediation to the fore now in the UK.
I do remember that mediation. It was a quintessentially English experience. I walked around the boundary rope with one party, and then I walked around the boundary rope with the other party in succession. We must have gone around about 16 times, but it did settle. I've had a question on the chat screen, Michelle. Well, give me a very quick answer to this. We're all talking about nudges, inducements, and indeed sanctions in the form of cost sanctions at the end of the day for people who don't mediate. Are we interfering with the parties' rights to access to the court, their access to justice? That's the question that's been raised.
Certainly not. It was raised as an issue by the Law Society in Halsey and Milton Keynes, and they expressly said that mediation did not interfere with Article 6 human rights, the right to go to court. It is, even if it's a condition prior to issuing litigation, it is no different from, as we shall see in other capsules later on in the Symposium, the multi-dispute resolution clauses that international companies now routinely have as part of their contracts. And the courts have upheld dispute resolution clauses which require you to negotiate before you, in fact, launch proceedings. And mediation is simply an extension of that. So it doesn't shut them out. If parties choose to go to court, they will do. But they run the penalty if they don't at least try at the beginning in good faith to resolve it through ADR.
I wanted to just bring in Tom for a moment, if I could, on this question. Tom, I'm dropping a question on you without warning. It's late at night where you are, so it's probably very unkind of me. But you have the experience of a mere 50 states to look at.
Yes.
And you've got about 30 seconds to give us. No, I've got more than that, but not much time. There are automatic mediation rules in some states, compulsory mediation rules in some states. As you look around, what do you think is good practice, and what do you think isn't working in all the various state systems? Give us if you could, a quick snapshot.
We truly do. Thank you so much, Bill. And let me just begin by saying, maybe I'll use my 30 seconds to thank everyone. I'm delighted to be part of this august panel. I was just going to tell you that I was involved in 2 conferences last week, one in New York and one in California, both of which were virtual like this conference. And we were talking, among other things, about some very signal developments in court-connected mediation. In New York, everyone would imagine one of our leading commercial jurisdictions, New York is now moving toward, in fact, has announced a presumptive mediation requirement for civil cases, which I found quite extraordinary because I thought New York had an extremely well-drafted discretionary rule with guideposts for commercial cases. I studied that at some length, and now all of a sudden they have moved to a blanket presumptive mediation program. I have to say I don't know how I feel about that. Normally I would try to dissuade people from adopting that because there are often unforeseen consequences. Mr. Justice Lam was talking earlier about ticking the box and, you know, mediation becoming nothing more than a whistle stop on the litigation train. And I worry about that. I have to say that in California, we have different dynamics. We have a constant battle between various stakeholder groups, notably the trial bar and dispute resolution organizations, the legislature, et cetera. And in California, there is an emphatic emphasis on confidentiality in mediation and drawing very strong barriers between the mediation process and the courts. And I know I've gone way over my time, but I'll simply say that most recently, through pressure from the bar, lawyers are now required to announce to their clients in advance of mediation the kinds of limitations on disclosure that may occur as a result of the agreement to mediate and California law, because there may be limitations on their ability to seek recompense from an attorney for malpractice, et cetera. So you've got all these issues on an ongoing basis that we're continuing to deal with even after 40 years of experimenting with these kinds of approaches. And I quite honestly don't know what the impact will be of the new New York experiment.
They had a pilot. They tried it out and concluded they liked it. I mean, I think is that the story?
They have had limited experience with it. That's correct. But you know, I have to say I remain. Let me just say I have a question mark over my head.
Sure,
we'll see.
Sure. I mean, yeah. I've had California attorneys come over and to mediate in London and describe some pretty ghastly box ticking experiences of being made to sit in a room with the other side and just literally sort of getting to 12 o'clock and packing it up and just literally ticking the box. I mean, that doesn't sound as if it's going to bring mediation into any kind of good repute. Presumptive means what? You can apply to the court not to mediate if you think. That's
correct. You can. Yes.
That they've just been discussed in London. It's being discussed in London too. Yeah, we shall see. All right. Well, look, we've got some interesting questions. Some of them look to me as if they might come up appropriately under one of the subsequent questions. So I'm just going to hold on some of them, but do please keep them coming because they are a really interesting underlying, to use the Hong Kong phrase, underlying theme of what we're doing. But I wanted to just move on to the question about what I'll call the mixed media question. And just to remind you, the question is, how does MedArb or ArbMed work? And what is the role of arbitral institutions in promoting the use of multi-tier means of dispute resolution? Now, we have in Tom and in Sarah Grimmer, two absolute experts in this area. I'm pretty much going to hand over to them to kick this one around. But Tom, because you're warmed up and running, do you want to start us off, and then we'll get Sarah to come in? That would be great.
All right, I will. I'll go ahead, and I'm going to go ahead and bring up my. Just one moment. I'm going to bring up my slideshow here. Hopefully, everyone will be able to see it. Are you able to see my slides?
Yes, Tom.
Yes, we can.
Thank you.
Yes.
All right. Very briefly, I just want to touch on a number of issues, and I make reference to what I call mixed modes, which I suppose runs the risk of being confusing, and I'll explain in a few minutes what I mean by that. I think one has to look at the big picture to see why we are more likely to be talking about these sorts of complex mixed processes or multi-tier processes involving some form of settlement-oriented conduct, negotiation or mediation against the backdrop of arbitration or litigation. I was interested to see these recent data from international commercial arbitration indicating what I think is an increasing amount of settlement against the backdrop of arbitration, varying by type of case. And I'll leave that for people to look at later with access to this PowerPoint. We also did a study some years ago in the United States of many of the leading commercial arbitrators here. And although you don't have statistics per se, the numbers here indicate that there has been, at least from people's perspectives, a significant shift toward higher levels of settlement for commercial arbitrators in the United States in recent years. Some of us have participated in the global pound conferences around the world, and I don't think one can count the responses of the participants as a scientific survey, but nevertheless, I thought it was interesting and significant that when people were asked, currently the most effective dispute resolution processes usually involve which of the following, the most popular answer was combinations, combining adjudicative and non-adjudicative approaches. This could be either arbitration or litigation with mediation or conciliation. Now, our panelists have a lot of experience, by the way, with all of these terms, including both mediation and conciliation. And before I go any further, really quickly, just to get this out on the table for our conversation, sometimes, in fact, very often, by statute or court rule, conciliation and mediation are treated as synonymous. And George Lim or Sarah Grimmer may want to comment on practices in their respective jurisdictions in that regard. The fact is, in some other places, they may not be synonymous. But often you do see when we refer to mediation, we're including a range of processes that may include conciliation. I'm currently involved with a couple of initiatives, including one by an international group called the International Task Force on Mixed Mode Dispute Resolution. And there are a series of different sorts of interplay between mediation or other forms of settlement-oriented facilitation and arbitration or adjudication, although we're focused primarily on arbitration because it's commercial dispute resolution. As was noted, stepped or tiered processes have become a staple of many domestic and international commercial contracts. And there is a significant body of law that is beginning to develop around these. I think there's still a lot of issues relating to the details of tiered processes and what makes successful stepped processes, which may involve negotiation and maybe tiers of negotiation, mediation, and then some form of adjudication. And of course, you have all kinds of procedural issues that can come up in the context of that. There's the potential for unforeseen, unexpected consequences, which maybe we'll have time to talk about later on. Nevertheless, we really have to come to grips in a more effective way with how these things work. And that means empirical studies and comparing and our experience. Then you have approaches that involve mediators setting the stage for adjudication. Some of us as mediators routinely, in fact, most mediators certainly would say, well, we mediate process, but that may go so far as to actually set the stage for details of arbitration. I'm going to move ahead since our ostensible focus is on what I call changing hats or switching hats. And we can come back maybe and talk about some of these other mixed mode processes. For example, there are other ways that arbitrators may set the stage for settlement. For example, in places like Germany, you have offering of preliminary views, issuing of preliminary findings of fact or conclusions of law, etc. What I want to focus on now, though, in the few minutes I have left, is MEDARB or ARB-MEDARB. And of course, when I refer to MEDARB, I'm talking about single neutral MEDARB, as opposed to any process where you have a mediation stage and an arbitration going on. And of course, in MEDARB, you have a scenario where if mediation does not initially succeed, the mediator changes hats and takes on the role of arbitrator. And then, of course, you have various forms of ARB-MED, where an arbitrator may shift to the role of mediator at any point during the course of arbitration. And then if mediation fails, perhaps the parties will agree that the neutral resumes an arbitral role, ARB-MED-ARB. So you have a lot of different possibilities there. And, you have a variety of reasons why you might have people resorting to a mixing of roles like this. Efficiency and economy, addressing the mixed agendas of parties, and making a very quick change to facilitate negotiation during adjudication or vice versa, crafting a negotiation while obtaining finality through a consent award by the neutral, if circumstances permit. Often you find that these involve continuing relationships or other special priorities and taking advantage of particularly strong rapport and trust with a neutral. It may also be, and I think this is very significant, a response to changed circumstances or changing circumstances. And recently I heard the example from a colleague of a scenario where they were in the middle of arbitration hearings. The proceedings were halted by COVID-19. After several months of delay, with the parties facing significant economic travails, the parties jointly approached the neutral and asked their arbitrator if he would be willing to turn to the role of mediator, because they simply could not afford to carry the case through to fruition through arbitration. So they successfully mediated with the help of their arbitrator turned mediator. There are a variety of concerns, which I'm sure we'll talk more about, and I'm simply going to list them here. And these have motivated a variety of different approaches, including a level of regulation in places like Singapore and Hong Kong and Australia. In Brazil, in the relatively new Mediation Act, they have actually prohibited MEDARB. They have prohibited mediators from shifting to the role of arbitrators, although they do recognize at least in the law, conciliation by arbitrators. But you do have these concerns that I think have influenced a lot of the practice in the US. I do want to indicate that although in the US, if you talk to a group of attorneys and dispute resolution professionals, the conventional wisdom is do not mix roles. The fact is that every group in which I have conducted surveys have revealed that at least a significant minority of the neutrals have had experience with mixed roles. And this is one of the reasons I find this so fascinating. And in fact, when we did a study of the International Academy of Mediators several years ago, I think that when you add together all of the numbers, a majority of the individuals in that group said, yes, we have in one circumstance or another shifted from one role to another in the middle of resolving a dispute. And in the IAM survey, of the people that actually had experience with mixed roles, perhaps it is not surprising that most of them said they had a generally satisfactory experience. And some described a mixed experience. A few said it was unsatisfactory. What are the challenges in developing normative guidance internationally? That is, we have different traditions, different cultural expectations about mediators and arbitrators. And for this reason, we really have a polyglot of different approaches. Many of our attendees today will be aware of traditional practice in China, in which mediation has been accomplished in connection with the role of the arbitrator or a judge or a government servant. So that's one kind of approach. In Germany, you have a very activist role for arbitrators, much like that German judges apply. And that's why you see, like the Prague rules have embraced, German arbitrators playing a pretty active role in settlement in many cases. In the US, as I indicated, there is a conventional resistance to mixed roles, but what you find is that a lot of people will take advantage of an innovative process like this and move forward, and generally with success, but not always. Then you have, as I said, a number of jurisdictions which have taken a proactive approach to trying to develop regulations. And I know we're going to hear from Sarah in a moment to talk about Hong Kong. And then finally, as I said, in Brazil, you have a scenario where they basically said in even embracing mediation in the first place, they said, we're going to put an absolute limit on these kinds of connections. So there have been a number of soft law guidelines or efforts to develop them over the years. CPR in the United States had a Commission on the Future of Arbitration that came out with a set of preliminary guidelines which cautiously embraced mixed roles and raised a number of red flags. The CEDAR rules went much further in terms of trying to create guidance for international arbitration and different kinds of facilitation of settlement. And now we are developing some new guidelines, relying on not only on the CEDAR rules, but a lot of experience and developments in different countries and by different organizations. And so let me just conclude by saying, I think it's absolutely essential that we develop shared experience and shared approaches, or at least shared expectations about how you manage these things, recognizing that there are a lot of differences in culture and legal tradition. And to say that there is a role, if a more limited one, for these kinds of mixed processes, but they must be used with care, with a level of sophistication. They must be a result of informed decision-making, and people should be aware of their choices procedurally. I probably took more time than I should have, and I apologize, but look forward to hearing from Sarah and other panelists on this topic. Here are a couple of articles recently produced on these topics. Thank you.
Tom, don't apologize. It's a fascinating subject. A couple of things ring a bell with me there. One is that when I've done mixed processes in which I mediate, but the clause provides that I will give a non-binding indication thereafter if we don't settle, the mediation is absolutely chilled by the fact that I'm going to be subsequently expressing a view, an evaluative view. Nobody makes a sensible offer because they think any offer will set a base for the award I subsequently recommend in my ideas. I've found mixing very difficult. Equally, a year ago, I was in Hong Kong for Mediation Week, hearing about Chinese practice, which, as you say, is much more relaxed about this. Clearly, the Brazilians are at one extreme, but at the other, in China, what was being said was, look, you've got some arbitrators lined up. They understand the case. You trust them. You've got some rapport with them. Why go off and find somebody else? Why go to the back of the queue for Mr. X when you've got, you know, Miss Y, who you've got a relationship with, who's your arbitrator? Why not use her? So interesting stuff. Sarah, do give us a HKIAC and a perspective and tell us how you see these issues. It'd be great.
Thanks a lot, Bill, and thanks a lot, Thomas, for your comprehensive presentation. You've covered there are a lot of issues that arise in this way. What I want to focus on is a few things. So looking at a few surveys that indicate that there is an increasing interest in multi-tier dispute resolution. And then I want to look at a survey that HKIAC conducted on over 1,000 dispute resolution clauses to see what we see coming through. And then a few comments about how arbitral institutions can play a role in promoting or facilitating the good use of multi-tier dispute resolution. So Thomas, you referred to the Global Pound series, which was a very important series of conferences and reached out to approximately 4,000 respondents. And as you pointed out, just under 50% reflected a preference or the recognition that the improvement of commercial dispute resolution would be found in the combined use of adjudicative and non-adjudicative dispute resolution methods, so involving mediation, conciliation, as well as arbitration. In another survey in 2018, the Queen Mary University of London survey run with White and Case, 49% of respondents, and there were over 900 respondents in that survey, indicated a preference for multi-tiered dispute resolution methods, and that was up from 34% from 2015, just 3 years prior. And what was interesting about that survey is that it was very pronounced, that preference, amongst in-house counsel. So 60% of in-house counsel expressed a preference for mixed method dispute resolution forms involving non-adjudicative through to adjudicative. And then there is an earlier survey run by an author named Diala Nigmatulina in 2014. That was a smaller survey. But what that survey indicated was that despite confirming interest in mixed mode methods of dispute resolution, the actual experience of mixed mode methods of dispute resolution was not so common. In fact, amongst her body of respondents, 1/3 had experienced it in person in the previous 5 years. And of those, less than 10% of those respondents said it was part of their regular dispute resolution practice. But from all of those surveys, there are 4 conclusions I think that can safely be drawn. First of all, that amongst in-house counsel and companies, what is key with respect to dispute resolution is that efficiency, time and cost savings is absolutely key. Secondly, that the search for cost savings, for time savings, is driven by in-house counsel towards early resolution of disputes. Third, that there is a global interest in combined dispute resolution methods. And fourth, that there is a demand for greater collaboration with external counsel around being able to enter into effective mixed mode methods of dispute resolution. And I'll come back to that because it's a bit of a theme that's coming up through a lot of the presentations. At HKIAC, what we did in 2018 was a survey of over 1,000 dispute resolution clauses that we see come through in our cases. And as an arbitral institution, of course, we have a wonderful vantage point because we see literally thousands of disputes and thousands of clauses. And what was interesting to see was whether the high level of interest in mixed mode dispute resolution was reflected also in a high number of mixed mode dispute resolution clauses. So we took a time period from the 1st of January 2014 through to the 31st of August 2018, so just over 3.5 years. That was the period we surveyed. And the results were really interesting. We found that of the clauses we looked at, 82% provided for arbitration only, so straight arbitration clauses. 17% provided for different and sequenced modes of dispute resolution. So just under 1/5 of the clauses we saw had mixed mode methods of dispute resolution embedded in them. And then the remaining 1% were unclear. They had different methods of dispute resolution, but they weren't sequenced or they were pathological in some way. Now, if we break down the segment of the clauses that provided for different modes of dispute resolution, they were by far the majority were, first of all, negotiation through to arbitration. That was 13%. And then of the 17%. Next was mediation and arbitration, and that was surprisingly only 2%. And then the remainder was adjudication of some kind through to arbitration. Now, one very important qualifier for our survey was that we were looking at essentially clauses that in the vast majority of cases provided for arbitration. Some of them were arbitration only, and as I've said, some of them were mixed mode methods leading to arbitration, but they all had arbitration. So we didn't have visibility over those clauses which may have had mediation or negotiation as one of the front steps, but which settled during those steps. So we only really saw the cases that came all the way to arbitration and weren't settled by some other form. A couple of observations about the different arbitration clauses. With respect to the clauses that provided for mediation and arbitration, that's what I want to focus on the most. So within that sector of cases, you could divide them between those clauses that provided for negotiation, mediation, and then arbitration. So essentially a 3-tier clause. And those were mainly found in construction and professional services contracts. One of the observations with respect to those clauses was that they were generally well drafted. And what I mean by that is that they contained clear, specific time limits and trigger points at which the parties would move from one phase to another, thereby reducing any procedural battles that you would find yourself in because of unclear drafting. Secondly, it was not uncommon for the clauses to specifically define the positions that the negotiators would hold. So typically CEO or some other executive level decision-making role. And finally, with respect to mediators, it was not uncommon for the clauses also to provide for specific qualifications that the mediators were to hold, and they were not always legal qualifications. In fact, what we saw was that there was demand for mediators with industry-specific qualifications. So for example, with hotel management agreements, we see requirements that a mediator has hotel industry experience. Secondly, what we saw in these clauses was an effort to avoid wasted time and costs. So you didn't find yourself in a situation where you were going through the mediation just for the sake of ticking the box. So for example, in clauses, the parties would provide that during the mediation, at any point in time, one of the parties could request to come out of the mediation and then commence arbitration. So there was that release mechanism in a number of the clauses. Then if we looked at the second type of clause, which was straight mediation to arbitration, as opposed to negotiation, mediation, arbitration, what was observable amongst that group was that they spanned a wide range of commercial contracts, all of your traditional commercial contracts, as opposed to the other set, which was mainly construction and professional services. They also referred to existing sets of mediation rules much more frequently. And also they were less well drafted, generally speaking, in that they didn't provide for clear time limits. So those were some of the observations that we found in our survey. And I think it's interesting because we do know that there is interest in mixing modes of dispute resolution, but we're not necessarily seeing it come out in the dispute resolution clauses we see. I think it's also interesting from the original surveys I mentioned is to think about what are the most common triggers for mediation and what are the detractors that come out. So with respect to the triggers for mediation, by far the most common was counsel's suggestion, then contractual provisions, thirdly, the initiative of a party, fourthly, a reference to an arbitral institution's model clause, and fifthly, legislation. What were the detractors? One of the main detractors coming through was that it was not a preference of external counsel for whatever reason, whether it be that they were unfamiliar with the method, they didn't have the appropriate training, or there was a professional divide between the mandate of the advocate who was there to win the arbitration at any cost, compared to the advisor to the party who was there to seek the most efficient, cost and time saving resolution to the dispute for the client. So different mentalities. What can arbitral institutions do to assist and facilitate in the different methods? I think there are a number of things. Of course, we can provide model clauses to parties that are clear, that are certain, that they can adopt then into their contracts. We can also make sure that the set of arbitration rules that we have facilitate moving in and out of different types of dispute resolution. And so at HKIC, I will just name a couple of provisions that we have in our latest version of the rules. Article 13.1, there expressly sets out the test for the parties to move out of an arbitration, and that is where the parties have agreed to a different form of dispute resolution. In that case, any party can request that the arbitration be suspended. The parties can then move into their alternative dispute resolution form, but at any time, any party can then request that the arbitration resume. So it's based on party agreement, but also unilateral request to move in and out of the other form of dispute resolution. Another very important change that we put in place in our newest set of rules, that's our 2018 arbitration rules, is the ability to apply for emergency relief in an arbitration, even before you've commenced the arbitration. This was based on an actual case where there was a pre-arbitral step of mandatory mediation, but the claimant considered that it needed interim relief before or at the time that it was needed to go through the mediation steps. So they applied to the courts because under the previous version of our rules, it was not possible to apply for an emergency arbitrator prior to the commencement of the arbitration. In 2018, we amended that so that that is now possible, so that you can obtain interim relief even while you're moving through pre-arbitral steps. The other important role, of course, of institutions is in respect of the nomination of mediators. And at HKIC, that is something that we do throughout the year, is nominate mediators to parties in their various disputes. And luckily in Hong Kong, we have a very deep pool of mediators, Hong Kong and the region, a deep pool of mediators with qualifications and specializations in lots of different areas, because we see a wide range of disputes coming through in our mediation. And then with an eye more to the future and thinking about the Singapore Convention, I think that arbitral institutions need to be able to respond to parties' needs under that convention in terms of providing certification, documentation to show that a settlement has been achieved through a mediated process that parties can then take to the relevant courts when they are seeking to enforce a mediated settlement agreement. Just quickly with respect to med-arb in Hong Kong, it's rare for an arbitrator to act as a mediator, and if the mediation fails, to then resume his or her role as an arbitrator due to fundamental due process concerns with respect to unilateral caucusing with one or other of the parties, and one side not being able to present their case with respect to confidential information that the arbitrator may have gleaned from that caucusing. This is governed by the arbitration ordinance in Hong Kong, and its effectiveness, well, is somewhat dampened by the fact that if an arbitrator, then mediator, then arbitrator is to resume the role of arbitrator, he or she must declare the confidential information that he or she has obtained during the mediation that is material to the arbitration. And so, of course, that means that parties are somewhat reluctant to share the confidential information in a fulsome, forthcoming way. So Hong Kong is one of the jurisdictions where med-arb using the same person is very rare. I've seen one case where an arbitrator has proposed it to the parties, but interestingly, in his case, what he did was he proposed it to the parties with the caveat that he would write the arbitration award, put it in escrow at HKIAC, and then if the mediation failed, the award would stand. The parties didn't take him up on that. Of course, that wasn't going to save costs around drafting the award, but it was a creative proposal to the parties. And I'll stop there. Thanks a lot, Bill.
Sarah, fantastic. There is just so much to discuss on this topic. We need another 3 hours at least. But I was going to go to George if I could, because of course ARB Med-Arb, driven slightly by an enforcement model that which Singapore has been at the forefront of and remains at the forefront of through the convention, but driven slightly by an enforcement model. ARB Med-Arb is something you've been working with for some time. Do you want to give us a snapshot of ARB Med-Arb as it's currently working?
All right. Thank you very much, Bill, for that. I want to go back a little bit to remind us of the Chief Justice's speech. And if you remember, what he said was, it's been 10 years. Mediation has now become an integral part of the administration of justice, right? And he talked about a change in litigation culture. So I'm really encouraged by this because I see the new interface between litigation and mediation in Hong Kong, in Singapore, in many other jurisdictions, okay? And it brings us to this question, what about the interface between arbitration and mediation in international disputes, okay? And I think many of the speakers talked about this. Just give me a moment, I'm just going to share screen, okay? All right, this is actually the title of our seminar or webinar. Yeah, and this is the Queen Mary survey, which Sarah referred to just now. All right, and you see the trend of increasing use of hybrid processes, survey of 2018. And they asked practitioners, private practitioners, arbitrators, in-house counsel, what was your preferred method of resolving cross-border disputes? Now you see the three columns. The blue column refers to the lawyers, the private practitioners. The light gray column refers to arbitrators. And then the dark gray or black column refers to in-house counsel. And Sarah is very right. There is a difference in views or culture, okay? So if you look at the center group of columns, the three columns, when they ask in terms of international, what was your preferred method? And in terms of international arbitration as a standalone mechanism, all right, the lawyers, the private practitioners said, yeah, 51%, okay? And of course, the arbitrators said 54%. But when they asked this same question to the in-house counsel, it was 32%, okay? International arbitration as a standalone mechanism. Now, if you shift your eyes to the left, to the other set of columns, when they asked the respondents, all right, what was your preferred method of resolving cross-border disputes, and looking at international arbitration together with ADR, which usually means mediation, most of it, the lawyers had said 46% said, you know, that was their preference. The arbitrators, 43%, and Sarah, you said this, right? For the in-house counsel, it was 60%. So this is quite significant for me because, you know, we sometimes practice as lawyers, as arbitrators, we think we know what the market wants. But for me, the in-house counsel represent the businesses, the parties, the clients. And if you can see that there is significance in the views, for me, there's a difference in culture here. And I'm just wondering whether or not we, just as the courts have done it with litigation, it does take some time. For us in the international space, for arbitration and mediation, I think we need a shift in culture as well, to see that realization, for us to be more aware of the needs of the market and not just what we think is right for the market. So that's just one thought I want to leave with you. And now, Bill, I'm going to address your question directly, which is on the ArtMed process. Okay, so very briefly, I think some of you know this, but just bear with me. I chair the Singapore International Mediation Center. We are a young body, just 5 years old, not for profit, but to focus on promoting cross-border disputes. Okay, we are a sister company of the SIAC. Not many people know this, I think, the Singapore International Arbitration Center. We work we work together with like the neighbors next door to each other. So 5 years ago, when SIMC was formed, and that was with the help of people like Edwin Glasgow, Michael Lees, I owe them a debt of gratitude. We thought, look, for cross-border disputes, enforceability was an issue, right? At that time, we didn't have the Singapore Convention, which would take some years, of course, to develop as well and to become effective.
没有新加坡的公约，那当然我们是花了几年才把新加坡公约做出。
Addresses the issue of enforceability for cross-border disputes. So we thought of the ArtMed protocol. Okay, Tom, you spoke about ArtMed. This is ArtMed because we wanted to ensure that parties, okay, would be able to enforce their mediated settlements. Right. So it starts this way. If you have a dispute and you're concerned about enforceability, come to us. We will register your case as a dispute, okay, with SIAC, as an arbitration dispute. A tribunal is appointed. It could be 1 or 3 arbitrators. Initial papers are filed, okay, and then the tribunal will order a stay of the arbitration for a period of 8 weeks, okay, so that people don't use a process to delay proceedings. So 8 weeks, and then the file, and all this is done backroom, okay, it's a one-stop process. The file is passed over to SIMC as a different organization, okay, and we appoint a different person as a mediator. We believe the people should be different for confidentiality, for ethical reasons, for different skill sets, okay. And then the case goes for mediation at SIMC during that 8-week period. Of course, parties have the right to extend the time if they wish. Now, if the case is resolved successfully, then you have a settlement agreement, and we then pass the file back to SIAC, who the parties will go before the tribunal, and that settlement agreement is then recorded as an arbitral award, a consent arbitral award, which becomes enforceable all over the world under the New York Convention. All right, so that was the idea that we had, a service that we wanted to provide. Why ArtMed? Because there was this question of whether or not people would dispute. If you just do MED-UP at the mediation stage, if you settle a case, someone might say, you no longer have a dispute or difference, you can't get it registered as an arbitral award. So we wanted to overcome any such objection. And that's why we did ArtMed. And of course, if the case at SIMC is not resolved successfully, then the case goes back to SIAC for arbitration. So either way, the parties get an outcome. Okay. So that was the service that we thought would be useful for parties, for clients, and the experience. And I want to share this experience. The experience has proven so. All right. As I told you, we are a young body. It's very hard for a startup to get cases. We started with like 3 or 4 cases in the first year, but we're now hitting like 40 cases a year. We've got a total of 130 cases, total dispute value of $3 billion US, settlement rate of 78%. Not too bad. And that's because we've got very good mediators on our panel. People like Bill, people like Michelle, like Jeff Grievous. Okay, so our statistics are we've had close to 20% of our cases are ArtMed cases, AMA cases, with a settlement rate of 75–80%. So that is the experience I wanted to share with you, that it's worked. I mean, from us in practice, it has worked. We've we've carefully thought of having separate people act as arbitrator, mediator. And I think that is the safe way. And it's also a good way, as I said, because people have different skill sets. And my organization, IAM, we take a lot of pains in having a good panel of mediators and help parties to select the right mediator. As Sarah alluded to, that's very important. Okay, so this last slide. All right, so this for me, this shift, all right, because of COVID-19, many of us have been doing online mediations, right? Tom, I think you've done dozens in the last month or two. This is a photo of an online mediation done at the Singapore International Mediation Center. Don't worry, these are just the lawyers, and we've got their permission for this photograph to be taken, so confidentiality is preserved. So this is a hybrid process, all right? Some of the lawyers in Singapore were here with us, and then the parties, you see on the screen, the parties were there, they're from all over the world. And we found this to be very effective. With masks on, with safe distancing. But with COVID-19, and I wish this thing we'll get over this quickly for the sake of the world. But right now, it's also forced us in a sense to do things online. And I think for those of you who've done online mediations, you'll know that more parties are coming on board because it's so much easier to do an online mediation now. You don't have to fly people in. It saves you so much cost. So my question is this. I mean, for arbitrations now, I think, and like that case that Tom, you talked about, the COVID-19 case, parties got stuck in the arbitration. Why not try mediation? Okay, and for me, this is the time for parties to consider met up, whatever. And the cultural change is this. Let's try and do what's best for the parties, for the clients to resolve their dispute. It's not just about, the business of getting disputes done, but a cultural change for us practitioners, whether it's arbitrators, as mediators, but to be able to think for the parties and let's find the best way for them. Design the best process so that they get their problem solved as quickly as possible. So for me, that's my contribution. Thank you.
George, brilliant. Thank you so much. Lots of interesting ideas there. I'm going to quickly ask Michelle a very high-powered question that's been tabled before then giving Michelle the floor on our third question, which is the role of dispute resolution lawyers in all of this. But the question, Michelle, is this, and it arises under the misconduct provisions of the Singapore Convention, which I think you had a degree of authorship of, if I may put it that way. If countries are going to take radically different views about what is appropriate in the mixing of med-arb modes and so on, is there a danger that a mediated settlement could be refused enforcement in a second country because that country thought that the mediator had been tainted by having had a different function or mixing his mediation or her mediation and arbitration roles in some way? That's probably needs about 3 years of postdoctoral research to answer that question, but you've got 30 seconds before I then put you on to topic 3.
Two quick answers. First of all, if you join the capsule running, I think on Wednesday, we deal in detail with the Singapore Convention, and I shall be dealing in detail with the defences and pointing out that, in fact, although it would appear to be a block to mediated settlements, when you analyse what the defences are, there's no danger at all. And of course, as far as the mixed med-arb-med we've been discussing, the whole purpose of the Singapore Convention was to remove the need for having a mixed system of arbitration, mediation, and adjudication. Because if you mediate under the Singapore Convention, all the countries which ratify it will enforce settlements arrived at in that mediation. And so the thrust of the Singapore Convention, UNCITRAL's purpose in devising it, was to avoid the need for creating, I don't mean to be rude, but an artificial system for enforcing a mediation settlement.
Got it. there is so much material that's come up in those remarks from George and from Tom from Sarah. I mean, we really need about another 3 days, but the problem is we've got to do a decent discussion of our third question, which really deals with, I think, external lawyers. How can dispute resolution lawyers help clients to explore ways of resolving disputes with the most efficient and effective procedures? Michelle, I'm going to hand this to you, but just listening to the discussion so far, it's clear that in-house lawyers, the people who actually work for these companies, are very impatient of lengthy periods of uncertainty and volatility. Sarah clearly has to deal with in-house lawyers who want the job done effectively, quickly, cheaply, and so on. External lawyers, looking at some of George's tables, look to have a slightly different agenda. And they are the gatekeepers in many ways. They've been referred to as the people who often suggest mediation. They choose whether they instruct Michelle Kalipetis or George Lynn for the mediation. In many ways, they're really, really important influence in all this. Do you think they do enough? How could they do more to guide their clients in these choices?
The short word is education. We've found in the years that we've been mediating and going to countries where mediation was at its infancy, the real bar to mediation being accepted commercially was the lack of knowledge of what actually mediation was and the advantages. As far as in-house counsel are concerned, there was a survey conducted by the American Arbitration Association in February 2013. And they conducted a major research examining the attitudes and experiences associated with the use of non-judicial dispute resolution. And they took Fortune 1000 companies, mid-sized and privately held businesses, and did a survey on their attitude towards dispute resolution. And they divided them into what they call dispute-wise and dispute-foolish. Dispute-foolish were those who said, we'll fight them, we never give in, we won't accept any compromise, we'll see them in court. And dispute-wise was the opposite of that, we'll use every means to resolve the dispute rather than go to court. Now, there were several interesting findings as a result of that survey, and the one that I usually refer to when dealing with why should we mediate is that the extraordinary thing was that the saving in management time and cost, and indeed the personal, which people sometimes forget, stress of litigating, resulted in the companies that were dispute-wise, their profit earnings ratio was 60% higher than the companies that were dispute-foolish. Now, you only need to lob that statistic into a boardroom discussion about what we're going to do with this particular dispute for the sense of mediation to be made clear. In 2004, which is a long time ago, there was a survey which is reported in the New Law Journal, and it came up with this surprising statistic that 47%, nearly 50% of respondents involved in commercial litigation admitted that a personal dislike of the other side had been responsible for driving them into costly and lengthy litigation. Now, again, if that's apparent to the board, the shareholders, for one, these days would have something to say about it. And so it's education that, fine, you can be tough, fine, you can keep to your principles, fine, you can uphold that wonderful word, a matter of principle. Well, one famous QC said in, I think, the last century, principles are like top hats. They're great till you stand on them. It's the same in litigation. We all know that fighting litigation for the sake of a principle is a loser. Similarly, fighting it for the sake because you don't like the other side, again, is a loser. Switching it around the other side, in-house counsel are concerned with two things. They have two pressures, which aren't necessarily those upon lawyers in private practice. First of all, they have a board of directors to answer to, where they have to justify steps they've taken in disputes, and in particular in instructing outside lawyers to resolve disputes. And secondly, of course, their own particular jobs are on the line if they get it wrong. Private practice, of course, one could say, well, one's own private practice, one's income, one's existence depends upon making sensible decisions. But the answer to lawyers who resist mediation, who somehow think that that's a sign of weakness, or somehow think that you get a reputation with your clients that you're a settler rather than a fighter, is simply this. I've come across, I won't name the jurisdiction or the person concerned for obvious reasons, but a very senior judge sitting in a Supreme Court in one of the jurisdictions where I was giving some lectures about mediation actually said, but Michelle, solicitors will lose money and they have families to support. How can we promote mediation in the face of that sort of complaint? When I was part of the working party drafting the European Code of Conduct for Mediators, one of the most eminent lawyers in Belgium stood up and actually said to the assembled EU administration, judges and lawyers, you're taking the bread out of the mouths of lawyers. Are you serious? I asked that particular lawyer and the senior judge one question. What are your clients' interests? And they hadn't actually thought about it. And lawyers who don't think about what is their client's interests won't address the issue of what is the best for my client. And I think that the Court of Appeal in England got it right in Halsey by saying it's your professional obligation to advise your client on whether or not your case is suitable for resolution by ADR, particularly mediation. And to do that, you have to be aware of what mediation is about. And that's why subsequently with the late Philip Norton, God rest his soul, we persuaded the Bar Council to include a compulsory module in the bar finals on dispute resolution in general and mediation in particular. And now there isn't a single barrister that I come across, and Bill, you and I are always mediating with barristers and QCs. All of them now are fully aware of mediation, and those who actually embrace it do far better for their clients than those who still think that litigation is going to get them a better result. And so it's education. And my firm belief is that in international disputes, the more companies use the multi-tier dispute resolution clauses that Sarah and Tom have referred to, the more that they will realize that you don't get anywhere near litigation unless you absolutely have to. And then you've got to just persuade the board that that's the right decision. And I defy almost any in-house counsel to justify that position unless there's a really either millions and millions at stake and the other side are being totally obdurate in terms of settlement, or whether, to use the dreadful word, there is a real principle that they're prepared to fight for. And the most common case, I think, is protection of intellectual property, trade secrets, are cases which would normally fight if there isn't an attempt to compromise in a mediation. And Bill, you and I both mediated those sort of disputes, and if parties are willing to mediate, there isn't a dispute in the world that can't be resolved in mediation, if the parties are willing to try and resolve it.
Michelle, thank you. George, can I just put this to you? I mean, Michelle's mentioned the compelling need to earn money. Litigation departments have targets these days. There's financial pressure on lawyers in relation to these things. I suppose we see that at work. And you also hear, there was an interview with the head of litigation at Debevoise in New York the other day, where he said litigators will often go to a beauty parade for a big piece of litigation, planning to advise the client on the benefits of early settlement and early mediation, only to find the client absolutely incandescent with rage about the dispute. They want blood, they want victory, you know, and so you somehow you soft pedal the bit about mediation in your pitch to them, and with any luck you get the job and you fight it. But and then at some stage later on you mention mediation. But those kind of pressures are at work, and do you see those as holding back the process of mediation? How should external lawyers deal with all of that?
All right. So you remember the old joke? We said ADR stood for an alarming drop in revenue, right? Okay. You know, I'm just talking generally. I don't think that's true. It's a myth. Because in 1998, when I was president of the bar in Singapore, and that was about the time when mediation was introduced in Singapore to the courts, a lot of emphasis. We had 3,500 practitioners on the road, okay, practicing lawyers. Today, when mediation has blossomed in Singapore, I mean, it is part of the process now. Lawyers do accept that there has been a cultural change. I think we've now got close to 5,700 lawyers. All right, so to me, the pie can be expanded. And if we as practitioners, as lawyers, are able to see that we can provide different types of services to clients, surely maybe in a particular case, your revenue might suffer because you mediated a case and settled it. But when you look at it overall, I think there's enough work to go around. And then, and for me, more importantly, that we've been able to fulfill our ethical duty to act in the best interest of the clients. And that means if you can settle the case early for the client, so be it. So you have I mean, we all come across this, right? You do a mediation, it's a juicy case, it's hundreds of millions of dollars at stake. And it could feed 3 lawyers in that firm for a year. And it's a dilemma for the lawyers, okay? But the good lawyers that I've come across clearly make a choice. Yeah, if it's good for the client and the client is willing, oh, by all means. And I think that's the way to practice, because the client appreciates that. And the clients come back, you build that relationship, you get a different case. You go to court, win, lose. You know, if you lose, you might lose the client. So it for me, it adds up in the end. It makes up. So I'm with Michelle entirely. I agree with him entirely. Education is important. Education at law school, at the postgraduate level, and in practice with mediation advocacy for lawyers to understand their roles. And in the end, I think it makes up, really. Thank you.
George, just to pick up on one thing,
yeah.
With one or two of the questions coming up in the chat have mentioned a lack of preparation quite often. This may be a Hong Kong experience. I think the Hong Kong questioner, people don't prepare, they don't get the kind of disclosure they need in advance of the mediation, they don't get the kind of preparation done with their client they should do in advance of the mediation, all of which obviously gets in the way of what we try to do. What's the culture like in Singapore on that front? Do you find people know that mediation involves a bit of effort and make the effort?
Okay, to be honest, I think it's a mixed bag. We now have lawyers who've gone through mediations. They understand what the process is. They've had a good experience. They know how to prepare for a mediation. And we run mediation advocacy courses. Okay, but there are still lawyers who do not have the experience and who will be better prepared. And this is where I think institutions come in. I mean, Sarah, I'm sure you've come across this, to help prepare the parties for the mediation. And what I mean is early exchange of mediation statements, conference calls to prepare the lawyers. In Singapore, for online mediations, we actually take the lawyers through the whole process. Exchange of people who are going to attend the mediation early so that you don't have disputes over that. And for the mediator to contact parties beforehand, which is what I do. I call the lawyers beforehand. By the time I come to the mediation, I know what the issues are. And I think this is an ongoing process, okay? For me, it could be better, but it will take some time, as in all things.
Sarah, when there's an HKIC managed mediation going on, and do you find that the external lawyers, just focusing on them for a moment, do Do they get it? Do they know that they have an obligation to really contribute to the process?
Yeah, absolutely. I think just going back to what George just said, I think, you know, a lot of how the process unfolds lies in the hands of the mediator. So you're really needing to be looking at appointing experienced mediators who know the type of dispute and can navigate the type of dispute, know what the type of dispute requires. I mean, it's going to be a different situation if you have a family dispute compared to a construction dispute. So I think that really it centers on appointing experienced mediators who know how to run the case. They've run cases before, and the lawyers, I mean, in our experience, it's, you know, I wouldn't say as a general matter that Hong Kong mediation is less prepared than any other mediation. That's not my experience. It's taken very seriously. So I think a lot of it comes down to the mediator and also the parties and how they want to run the mediation.
Jody raises the question of Hong Kong's mediation settlement rate being relatively low at 50%. Any thoughts on that?
I'm not sure if that's low. I mean, compared to what other jurisdictions, 50%, you know, glass half full, glass half empty for the 50% of cases that settled. That's quite good. You know, I think compared to arbitration, when you measure the number of settlements in arbitration, I think we looked at that a while ago, and it was about 15% per year of cases. That's not scientific. I can't, you know, get into the details, but I think it depends on where you're coming from. That's not too bad in my eyes.
And also on the 50% figures, I don't know whether what is the base figure. I mean, as I've said, in the course experience, there are quite a number of cases which just tick the box. Of course, if you took those cases into account, the percentage would be lower. And the purpose of we having this new initiative in terms of case settlement conference is for the court to tell the lawyers, it was just go to a mediation for taking the box. Don't do it, because it's just a waste of everybody's time and money. We want people to attend mediation with the hope to achieve settlement and to attend with sincerity. And that is what we try to educate by means of this case settlement conference, because at the conference, the master, who would be an experienced mediator as well, will also kind of explore, maybe not in great depth, but would explore with parties if they have attended mediation previously, what is the stumbling block, and hopefully with that in place, and also with the participation of the parties themselves to that process, they can be talking to having a more sensible approach towards mediation.
One of the things that they've done in Singapore is to, excuse me, to copy the Ungli order I referred to earlier and require solicitors actually to depose that they've advised their clients on mediation and set out the reasons why, if that is their advice, the case is not suitable for mediation. Now, a variant on that, I don't know whether it might be useful in Hong Kong or whether your lawyers would allow you to do it, or the system, is to copy the example in UK that solicitors have to swear an affidavit, which is sealed, before trial, setting out why they say they've advised their client that mediation isn't suitable. I mean, they have to sit down without knowing the result of court and actually think about why they are rejecting it. I think it puts them in a difficulty, particularly if costs can be disqualified as a result of getting that particular decision wrong.
I mean, it sounds as if the mediation certificate that Justice Lamb described at the beginning fulfills a very, very similar function to that. So I think great minds have probably thought alike on that. Can I just quickly ask Tom Stefanovich, we're in the dying minutes now. I want to go back to Justice Lamb for a last word, but Tom, just external lawyers again for a moment. Clearly, in a sense, the the US experience is longer and deeper than certainly than the UK experience. Generally speaking, is mediation now regarded as absolutely standard, accepted part of the litigation culture, or is there still a lot of resistance?
You know, I think if I had to answer that yes or no, I would say yes. It has been accepted as a part of the litigation culture. It varies considerably what that means. I will say that most mediators, myself included, believe that lawyers are very often friends of the process and welcome the process as an opportunity to resolve a dispute or address the scope of issues, etc. There may be great value one way or the other in mediating. Obviously, along the way, you have a lot of things that happen, and very often lawyers use mediation for a variety of other reasons, including just delay, obtaining information, etc. So it's a very mixed bag. Although maybe it's just my idealism about mediation and that of other mediators that we tend to say, on balance, lawyers embrace the process for its highest and best use.
Very good. Tom, thank you. Justice Lamb, can I just go back to you for a very last word? You listening to this brilliant panel discussing all of these issues. Are you optimistic or pessimistic, or how do you think it looks?
I am realistically optimistic.
Excellent. Very good. I can't beat that. Listen, I think I'm just about out of time. I'm about to get cut off, but I do want to thank the panel who've all contributed brilliantly to that discussion, and it's been extremely entertaining and very informative. And we couldn't have had a better panel in any way. But that looks like 3:45 a.m. my time, and that's I'm going to hand over to Jodie now.
Thank you, Bill, for doing the moderation of this wonderful session for us. And on behalf of the organizers, HKMC and IAM, I would like to thank all the speakers, all the panelists in this session. And to all the participants, we have 5 more capsules upcoming. The next one will be 12:45 this afternoon. So I look forward to seeing you all. Thank you very much.
Thank you so much, Jodie. Thank you, Bill.
Thank you.
Thank you, Bill. Thank you, Tom. Thank you, Sarah. Thank you,
Great to be with
George.
you all.
Thank you.
Welcome to be with you.
Thank you all.
Take care.
Thank you.
Good to see you.
Thank you.
Bill, are you still online? Jodie?
Yes.
Is it an hour now to the next session?
Correct. So
right.
it's now 11:45 in Hong Kong. Yeah.
Right. Well, I'm going to have to come in and observe. Do I have to come in on the separate link for that? I think I do, don't I?
I think in the email to you, we have the links to all the sessions. That
Yes.
one was sent by Sam.
I've got it. What I'm saying is I can't stay on the line on this session and automatically go into Capsule 3, can I?
No, so you can leave this one first and then you use another link to join. Yes.
Good. Well, Tat, I hope to see you a bit later on. And Jeff, if Jeff's still listening. And Nadia, of course. And indeed, Jodie, you're part of it as well.
Thank you.
All right. Thank you very much indeed. You take care.
Yeah. So we'll see you in an hour's time. You don't need some rest?
I'll I'll go have an hour's sleep and come back. All right.
Okay. See you later.
Bye-bye.
Bye.